All right, welcome back to another special episode of The Unknown. My name is Michael Volpe. I write at michaelvolpe.substack.com. I'm in Chicago, Illinois. That's in Cook County, Illinois. My broadcast partner, Richard Luthmann, with two N's. It's luthmann.substack.com. He's in Lee County, Florida. You never know exactly the city. All the cities suck anyway in Lee County, and I know it's named after Robert E. Lee. And we are joined by Matt Grant. He is a candidate for Congress, and we'll talk about that in a minute. But last week, Rich and I were critical of the lawsuit you filed, and you wanted to come on. Well, before you explain the lawsuit, before you give a defense of the lawsuit, let's break it down. You are a litigant in St. Louis County, their family court system, and you're a longtime attorney, though I think you've taken a sabbatical. Doesn't mean you've forgotten the law. St. Louis County, which is where I and my former friend Megan Fox did for about a year. In fact, you cited both of our stories in parts of the lawsuit. We found that there were widespread problems. I believe it's a criminal enterprise, but that doesn't mean that I could prove it. You filed a lawsuit that was primarily about your case, but you left open the possibility for a class action lawsuit because you believed that there was a widespread pattern. The lawsuit got a lot of attention initially. I think a lot of that had to do with your resume as a litigator. I think both in state and federal court. But the judge, Josh Devine, a Trump appointee from his first term, didn't like your original lawsuit. Didn't like the amended lawsuit. Not only did he dismiss it, but I think possibly you may be sanctioned, which Rich and I didn't talk about. He let's just say, like if he wants to make you pay money, and you were representing yourself pro se, but he disregarded. I think he correctly disregarded the argument by saying, but you pass yourself off, not your pass. You are an attorney. You're an experienced attorney, so you shouldn't get any leeway just because you're representing yourself here. So I don't think you've got a problem with that argument. We both felt that you, in effect, you didn't like the decision and wanted to, as Judge Devine said, in effect, forum shop by saying, well, I don't like what's happening in state courts. I'm going to dress this up as a RICO lawsuit and let a federal judge handle it. And he didn't like that, and there are rules and precedent against that. But basically, you were arguing that your case specifically, and then larger, the St. Louis County family court system is a criminal enterprise. That's what RICO is, Racketeer Influence Corrupt Organizations Act. The judge that is, said he didn't see any evidence that it was a haphazard lawsuit. I don't think he used the term shotgun pleading, but it certainly came close to calling it that. So your response, I think you've told us you want to appeal. You're confident in the appeal. What do you say?
Yeah, so there's a lot there you just threw out. But yes, my current intention is to appeal the dismissals under Rule 8. There's one section of the order under on a judicial immunity and then an issue with the guardian ad litem. But it's clear that that's not why he dismissed the complaint. But yeah, I mean, I think if you look at the law, and this is where I want to back up. If you look at the structure of my complaint and the legal theory, it's solid, right? So this is the problem for those that are engaged in this unlawful conduct. Is the way to attack these people is what I did. Is you can't seek money from judges. There are rare exceptions, but what you can do is seek prospective injunctive relief. And that's what I did. I said, I'm not looking for you to change my custody of my kids. I'm not looking for any of that. So he's wrong that I'm looking to overturn. That's why those cases are inapplicable. I'm not asking to overturn anything in the state court judgment. But to your point, when this all came to a head, I didn't get a judgment until October of 25. I exposed this to the Office of Chief Disciplining Counsel in Missouri in December 24. And I disclosed it and reached out to the United States Department of Justice in January of 25. After I had only appeared before Hilton the first and second time, Actually, I think it was between those two, and before he had ever issued an order against me. So that's why this just, it's a non-starter argument that this is some sort of reactionary conduct. And that, last January, I had no idea what the ultimate judgment would be. And I filed this case in August of 25. I didn't get the trial results until October 25, in which my custody of my children was doubled. So this whole argument that I'm a state court loser is it's
all right. And I think that might have some merits. And we're looking at there was an initial complaint that he didn't like, so he asked you to amend it. This is the amended complaint. And I'll leisurely scroll through it as you go along. And you mentioned Hilton. That is Judge Bruce Hilton, a notorious judge out of St. Louis County, who was on your case. And I covered the Vandenberg case, which with the and this is the part of the order that I didn't like, with the very notorious email, "We're buying future litigation," where apparently Judge Devine can look into the minds of people writing emails who are not in front of him and know what they meant. So he definitely is a notorious judge, but even taking that aside, he had a problem basically saying you say it's RICO, but you're not providing the facts that back that up. You're not giving number one, it's haphazard. Some things you claim are being done here, and they're also in the courtroom, and none of it rises to the level of a predicate act. So how do you respond to that?
Well, he ultimately dismissed it, said it was implausible. So that was the plausibility argument, is where he's hanging his hat. And that'll be the issue that goes up on appeal. In addition, under Rule 8, because he brings in Iqbal and Twombly ultimately and says, listen, what this guy is saying cannot be true. So he's acknowledging, I think, that my allegations lay out a RICO conspiracy, criminal enterprise, but he just disagrees. He said this could never have happened. This is implausible. The more likely scenario is this guy just doesn't like what happened to him in state court. And so A, that's factually untrue, but B, that's legally baseless and reversible error. Is, if there are two plausible explanations, the trial court can't, or the trial judge can't just say, well, I pick one over the other. You have to accept all the factual allegations are accepted as true, and he's trying to get around.
Yeah, correct me if I'm wrong. He dismissed it at a very early stage. Isn't he supposed to, at that stage, accept the facts as beneficial to you as possible? Without that doesn't mean that it's true, but for an early motion to dismiss, he has to say, yeah, even if all of this is true, I can still dismiss it. Isn't he supposed to accept the facts as you've laid them out?
And in fact, he acknowledges that in his order, and he says, well, generally, and then he states the proposition of law, which is it's not just generally, always the plaintiff's allegations must be taken as true. So, but then what he does is, instead of conducting an analysis, assuming my allegations are true, he switches to Rule 8, which is a different standard. And then he goes through and says that he didn't agree with the way I laid out my allegations. He didn't agree that they were plausible or coherent. And I want to point out that what you have on the screen is exactly what the judge should have analyzed and referenced in his order, and he didn't. So that's from December of 25. That's the most recent proposed Second Amended Complaint, which I put a lot of time on, and it's a solid complaint. And I think maybe it was an oversight, I don't know, but the judge references only the First Amended Complaint from September. Because so what happened between September and December were there were motion to dismiss practice. So in light of all of the arguments made by all the defendants, I corrected everything. So I filed an impenetrable complaint on December 23rd, 2025 that you have on the screen. And that is the one that, if it were actually subject to the court's review, I believe certainly will survive scrutiny on appeal.
All right, Rich, what do you think? Is Mr. Grant making a solid argument here?
Yeah, there's a bit of a tension here that I'd like you to talk to, Matt, for the civil procedure nerds that are watching. You said that Judge Devine looked at Rule 8 and the short and plain statement requirement, and you said Twombly and Iqbal, but also you're pleading RICO, which brings in Rule 9b. And that requires particularity especially for fraud-based allegations. And there were plenty of that there. Do you think the court punished you for pleading too much detail when RICO and fraud actually require detail?
Well, that's exactly right. So, it played out actually ironically, because at the end of the day, he says, well, all of this, you should have added more. He said, well, you don't plead all this, the proof of the pattern and all that, which I actually did in my Second Amended Complaint. I think I did in my First Amended Complaint. But that's exactly right. Rule 8 has to be read in conjunction with Rule 9, which is I had to list all this out, right? So I cut it back to 78 pages. I think it was 183 to start, which admittedly was a bad approach. But the Second Amended, or First Amendment, Second Amended Complaint were roughly 78 pages long. And I go through methodically, chronologically, exactly what happened. And what I did here, and the reason additionally why it's so long, is I included actual evidence. So it's not just allegations, screenshots. I have evidence throughout this complaint because I knew that it's going to be hard for any judge, much less a federal judge, to look at this and say, oh my gosh, is this actually true? So I included all the evidence to lay it out there.
Isn't he supposed to assume it's true at this stage?
He is, and that's exactly right. He has to. That's the law. So He tried to get around that by saying that my complaint was disorganized, and that, one of the complaints, which I think falls flat on its face, right? He says, well, you incorporated your allegations in your 300 allegations into each count. That's everyone does that, right? So you do a factual background section, and then you do your counts. Instead of reiterating all the facts, you just incorporate them by reference. So that's the standard trial court technique. He certainly he was looking for reasons to throw this out from the get-go. You could read his initial show cause order. He just didn't like what I was alleging. It's difficult to listen. I'm the one that got caught up in it. I couldn't believe it when this happened. It's very hard to accept that our court system in St. Louis County is as corrupt as you, Michael, reported years ago. It is that corrupt. And I'm a member of the Missouri Bar, the Illinois Bar, a number of federal courts, and I have no hesitation saying the family court system in St. Louis County, the 21st Circuit, is plagued by corruption. And they just don't want that out there.
I agree. And I definitely have a problem with how not only did he how do I conclude what that email said, we're buying future litigation. We kept going back to that email, even though that email itself is of little relevance at this stage. You were using the email to show that it's widespread. And also, I think, to say this is one reason why you should allow it to be a class action. But it's irrelevant if the facts of your case aren't enough. So I don't know why he kept going to it. But it is corrupt. I've shown it's corrupt. But people acting unethically does not mean it's a criminal enterprise. So explain to the audience, how was it a criminal enterprise? How was it a criminal enterprise based on the law of RICO? And RICO is that there's a criminal organization that can be as little as one person, but in this case, it's a whole bunch of people, and they all contribute, and each of them contributes at least 2 predicate acts, which are mostly crimes, things like perjury, forgery, murder can be a crime if you're a part of La Cosa Nostra, which pretends isn't real. How were these people contributing to a criminal enterprise? What were their predicate acts? Why didn't Judge Devine see the map, if you will, that you were laying out?
The map is, let's look at just 2 predicate acts: obstruction of justice and mail and wire fraud. So all you need to do is look at those 2. I actually specifically list all of the predicate acts that apply in this case. And I cite them throughout as examples of here and there. But that's exactly what they do, is they file electronically false pleadings and make false representations to the court, which is in and of itself wire fraud, right? So,
what do you mean by false?
Oh, well, you name it. I can give you a million examples, but here's how it started.
Give like 1 or 2 so people understand what you mean by when you say false.
Sure. So in my case, we had reached a tentative agreement on the front end. on that I thought was going to wrap all this up. And then it just disappears, and the guardian litem files that he says, oh, that didn't happen. I mean, it happened. I mean, we reached an agreement that the guardian litem changed his position, said that never happened, and it allowed the case to proceed another 4 months. And then you go to the court of another 4 months, and then you have parties making false representations to the court, which I've proven. I have all this in transcripts. There's false representations made to the court by counsel that are named as defendants. And the goal is, and they take specific actions to prolong the litigation. It's all about putting money in their pockets. I have, and this doesn't even come out. I have a whistleblower. I have a therapist counselor who as a master's in social work, who's going to testify at trial. I haven't found this. I found this individual after I filed that complaint. But I mean, I have all of this I've built over time, which is I have a witness to every allegation. I wouldn't make an allegation if I didn't have a witness to swear under oath to take the stand, and one that I've interviewed and that's credible. So that's what's going on here. It's just every case is a little bit different how they do it. But that is the goal, and the strategy is, what do we do here to prolong this? And I used the earliest case, Michael, that the judge references it critically, but it's the same judge. The reason I picked it is this Judge Hilton.
That's the Vandenberg case.
So I cite I cite a case from 20.
As I said, I had a big pride in it. He ironically used that me thinks those protest a bit too much. I thought the judge was protesting that email a bit too much. And you're right, that Hilton presided over, that's the Vandenberg case. Caroline, the mother, got that because she sued civilly. That was part of the discovery process. I agree with you that you could find a pattern, but he's still I think the pattern was separate because you first have to show your case. But basically he's like, you show this, you show that. You're not showing a criminal enterprise. Just because someone said something you don't like doesn't make it a criminal enterprise. So how does it make it a criminal enterprise?
So it's a criminal enterprise because it's a subset within all of the family lawyers and all the guardian litems in St. Louis County. There is an inner circle, and this is based on conversations that I have with my own former lawyer. Like, I'm a lawyer, and I sued him for malpractice, so I waive privilege to a large extent. But so I don't hide. I don't have nothing to hide when it comes to waiving privilege. But I know approximately what the prize is. The judge took issue with it, which is shocking. That to somehow he says, well, it can't hit. There's no way it could be as broad as 70 people, and that's just outrageous. Because there's been previous cases, and we can go through them. But in Cook County, there were 92 court officials indicted as part of Project Operation Greylord.
But wouldn't you also say that that's not your call to make at this stage?
Well, that's the point. I said I put some John Does in the first one. He took issue with that because he said I put that I was going to sue 100 more defendants. What I told him this case is about is two judges, a judge and a commissioner. That's all I'm asking the court to address. Did this judge, the commissioner, I caught an ex parte communication with the other side that I turned in to the ethics commission, and the judge that followed, who put on a charade, and I have evidence, I have corroborating evidence in hand to prove all of this, by the way, since all this has been filed. So I mean, I have the goods. I have the receipts on this guy. When I say this guy, I'm referring to the judges and the defendants as a group. These folks, I have the evidence, and yes, accepted as true. And he's saying, well, I can't go in there and do this, that, and the other. And what I told him, and I don't think he liked this, is I'm presenting a judge with proof of Civil Rights Act violations in the state court. And I understand that federal courts typically don't intervene in state court actions. But here, it's blatant unconstitutional. Due process rights, you name it, have been stripped from parents, and the kids are suffering in St. Louis County. And the federal court has to, under the supremacy clause of the Constitution, intervene. And it specifically references state court judges. He just didn't want to get involved because I was asking him to enjoin, as a judge, a state court circuit judge and a state court commissioner. and he was uncomfortable with that, even though taking my allegations as true. That's why I think, in my opinion, I think his order was artfully drafted to address certain things and avoid others.
Rich, what do you think? Anything else you wanted to add?
Your complaint, Matt, it says that the enterprise's playbook is to prolong litigation, increase attorneys' fees, GAL fees, evaluator fees, therapist fees, and pressure settlements. You say you have documents. What's the cleanest document or event that shows that playbook in operation?
You just because you have it on the screen, right? So let's go back to that email. And I think this will give folks, they really need to understand the flavor of what I'm going through by pursuing this. So that email, when that's on the screen, that's the buying future litigation, right? So you could interpret that multiple ways, right? I don't know how this judge is able to discern that his interpretation is correct and mine is incorrect. But in that same case, I'm sorry.
But he's not even supposed to interpret it at this stage.
On that, we agree.
Right. I want to also add, these are lawyers for Caroline, and Elaine Podlowski right there is the guardian ad litem. Whatever was happening, this email was completely inappropriate. They weren't sharing that email with the other side. They were obviously trying to hide things. That's great evidence. The Zoom conference that I released is great evidence. But as I said, I think that's a separate issue because you've got to show it in your custody case first. So what's the evidence in your custody case that the whole thing was designed just to prolong things?
Well, I have a transcript of me testifying on February 7th, referencing what happened on January the 21st. I allege that they manipulated transcripts, so I don't know how they missed this, but it left it in there. I have it in my hands as part of the state court appeal, where I referenced the judges. What he ultimately did was put on a charade on the very first time I appeared in front of him because he knew I wanted to get out of that courthouse and I wanted to go to the Missouri Supreme Court and I wanted to get out of in order to be assigned a judge from a different circuit because I had figured out that courthouse is a snake pit. I don't know whatever phrase you want to use, but in any event, so I have the evidence that I cite back to the judge on what the position he previously took, which said he came in and agreed with me. Mr. Grant, you suffered. Your children have suffered. Let me consent to me. Let me keep this case. And then I did. I consented to him. I made the mistake of consenting to him, and then he flipped. And then he realized then he 100% against me. So if you're looking for, however, an example, the next thing I did was file a motion to disqualify him for bias, right? After I had filed the earlier one. Then once he outed himself, I filed that. He never ruled on it. So I took what's called a writ to the Court of Appeals. 24 hours after I filed my writ, he took my children from me 100% of the time. No basis whatsoever, pure retaliation because I had exposed it. And that's what I did is I knew it was going to be a big deal. And I exposed it to the Court of Appeals and wham, he yanked my kids.
But I think what Judge Devine had a problem with is that I think that's what's referred to as conclusory, that you have these set of facts and you are assigning intent based on a set of facts. And just because you say that's the intent doesn't make it the intent. So I don't know if I've got.
So I think you have that a little backwards. So conclusory is a statement that is a conclusion without facts. Mm-hmm. What I allege and throughout my complaint, and specifically I cite to dates, times, and filings by document number or by document name and dates where they're filing false documents. I cite to it all in there. There are facts. It's on pages 18 through 22. Paragraphs 118 through 122.
We happen to be on page 18. So
that
was very fortuitous. So as you go on, people will see exactly what you're talking about. Go ahead.
So let's look, I'm just looking there at 119.2. Mm-hmm. And he takes a shot at me in his order by somehow implying that I don't have what I do have. It says plaintiff will present the testimony of FBI credentialed Missouri licensed attorney to confirm this allegation. And the allegation is that I was being gang stalked and surveilled. Well, not only do I have it, this witness already testified. I'm going to submit the transcript. This witness, I called it my trial. So to some extent, he walked in, I think the judge made a mistake there, because I'm going to hand that transcript to the court and say, this is a lawyer who did train FBI agents at Quantico, and he testified to confirm that these things happen. And that's what I try to do, is you don't have to take just my word for it. I've got all this other evidence.
Rich, I've got a few more questions, but I think I've been monopolizing.
Tell me, there's a part of the Second Amended Complaint where Fenley offered a quid pro quo. He wanted more custody. He was going to give you more custody in exchange for abandoning the corruption claims. That's a crazy allegation. It blows your mind that happened. But tell us exactly what happened in June of 2025. How did that happen?
So I had taken a writ previous to that. We were on the verge of trial, and we were currently up on an existing writ in front of the Missouri Supreme Court. I was asking the issue I raised, which is whether or not Judge Hilton should even be my judge, right? It's undisputed that there was an order that came down from the Missouri Supreme Court on March the 4th that he didn't disclose to me till I took a writ and exposed the corruption on March the 26th and 27th. He later that same day, then he all of a sudden, oh, look, I have this order from the Missouri Supreme Court. So, but anyway, that's just one example of the appearance of impropriety, which was up. But I have disclosed this audio recording. I made a recording of it. I've disclosed it. I've attached it, given to the Missouri Supreme Court. I don't think I attach it here. I can, but it's out there. So this guy, this guardian ad litem, he's the same one that lied to my children. Every 2 months, he's like, okay, this will be over next month. This will be over next month. Next thing you know, you blink and it's a year, almost 2 years later. Right? I mean, it's outrageous. But that's the scam, right? So he called me and said, listen, here's the deal. I can get you your kids back. And only thing he asked, and it's on the recording, is you just have to agree and drop your allegations of criminal conduct. And that's all he wanted. He didn't ask for anything. I was and continue to be an awesome parent. There's no allegations really that I wasn't. And so that's all he had to hang his hat on was, hey, drop this and you can have your kids back. And what I did was record them and submit it to the Missouri Supreme Court. And then after trial, he says I should get my kids twice a month. Instead of, I had him 4. Then he says, oh no, this guy after trial, he should get him twice a month. Judge Hilton, after I had sued him in federal court, he doubles my 4 to 8. So I now have my kids 8 days a month. So far from a state court loser. The judge is misconstruing or misinterpreting my references to the state court, which is I'm only at the federal court because I've gone to everyone at the state court. I've gone to the Judicial Commission. I've gone to the Ethics Commission. I've gone to the Court of Appeals. I've gone to the Missouri Supreme Court. No one, and we can talk about why. St. Louis County, in my opinion, St. Louis County Family Court, it's the second largest. First of all, the circuit's the second largest in the state behind St. Louis City. It's too big to fail is what I believe they've determined, which is what is the ripple effect of anyone acknowledging that what I'm saying, and Michael, what you reported, that this is all true. What does it do to the justice system? And I address this expressly.
It is a very big deal. There were, I think, 38 guardian ad litem on that call, and during the Zoom call I'm talking about, and during the call, they referenced that a lot of people couldn't make it because there was a conflict. So you're talking about maybe 50 or 60 just guardian ad litem who anybody on that Zoom call, you can watch it because they're talking about ex parte communication. They're trying to hide how they pay for Elaine's forensic person. They're doing all kinds of talking about all kinds of unethical things. If you're on that call, you're unethical for certain. And as I said, if you got 38 on the call and more would have come on, except they had something to do at the time. And then we probably found at least half of the judges who had all kinds of problematic cases. So it is like widespread through the system. I think I want to ask this, and I know I'm monopolizing, so I'll get it back to Rich. Basically, what I meant by conclusory is you show a set of facts, and then you say it has to be nefarious. but it doesn't have to be nefarious. And the law, am I wrong that the law doesn't, like, just because the judge decided to take away custody at a moment that looks like it's retaliation doesn't mean the law has to accept it as retaliation? Or am I wrong?
You are wrong. So whether or not it's good faith or bad faith is something to be proven by the evidence. It's not conclusive. What I'm saying, there are two alternative explanations. And that's what the court is saying. I'm alleging it's one. The court thinks it's the other. My point is the law allows me to prove it to a jury. There's a stage, obviously, you guys know about.
So it sounds like he should have accepted your facts, your evidence as fact, as it's supposed to be at this point. Am I wrong?
And he can't, because if he does, then my case goes forward to discovery. And then I get the judge's bank accounts, I get the emails, I get the cell phone records, everything no one wants me to have. And because I can put this all, I mean, like I said, I found who followed me, who followed other people. I mean, I have so much evidence on this guy. And back to, I'm sorry, that email that I want to get this out there. The email you put on the screen. In the first two versions of my complaint, I redacted the name of that law firm. Now on this version, on December 23rd, I decided just to put it out there and let it be known who the authors were, what law firm was in play.
Right.
Guess what happened later the day that I filed that? I was criminally charged with harassment by the prosecuting attorney for my municipality where I live, who was a partner at that law firm. I mean, it's just outrageous. It's what I'm saying is I have thick skin and I can keep taking it. But what I got, the retaliation that I've gone through, and I'm not looking for sympathy, but I give you this as more evidence of I have uncovered what, Michael, you started this, and I have put the meat on the bone, and I'm ready to move forward. And the court dodges the issue that you said, dodges accepting my allegations as true, because then it would mean something that no one wants to acknowledge.
Right. And I want to add, Kent Gerard filed, I would say, kind of a similar lawsuit to yours, a RICO lawsuit in Northern District of Illinois, where he made allegations that judges were being bribed by attorneys. And the judge did not say, oh, this is so fantastical, I won't even. The judge did say, at this stage, I have to accept that it's true. And she mentions very quickly they deny it, but she still dismissed it against the judges. But so in other cases, they have accepted it as fact, but because that's what is supposed to happen at this stage.
But here's why, Michael. Let me explain to you why that judge accepted it. Because that judge knew it could accept the facts as true and still dismiss the case because the plaintiff sought monetary damages. So the judge didn't have any issues. In my case, the judge can't accept my facts as true because then I'm seeking prospective injunctive relief, which is an exception to judicial immunity. And that's what I'm saying. Now, my goal all along is prepare a template complaint that if this is found and other people have the evidence to support it around the country, this will work. Maybe it needs to be shorter to survive. And apparently, 70. I mean, there's what, 12 defendants,
I've got
78 pages long.
Yeah.
But if you look at it's a class action out, there's multiple pages on the class action piece. But not only, so if you pare this down, the legal structure is sound. I state a cause of action, and this will work in the future. I'm going to, and I put this in my first complaint. I predicted this would be dismissed. There's no doubt this was going to be dismissed once at a minimum. So I get to go to the 8th Circuit finally and put my evidence in front of the 8th Circuit and say, look what's going on in the state court in St. Louis, Missouri. You're the 8th Circuit. You're a level above St. Louis, and you include circuit judges from around the Midwest and basically, well, obviously within the 8th Circuit. Are you going to let this fly? And we're going to find out an answer as to whether or not, my allegations taken as true, whether someone is going to green light this case just moving forward.
All right. I'm going to give Rich some time, but you're selling me that I did have some qualms with things that Judge Devine said. You're selling me that I think he doesn't want to deal with the ramifications of what your lawsuit is trying to do. Rich, ask several questions. Don't let me interrupt.
I have two questions about the 8th Circuit. First, if they send this back, right, and you win in the Eighth Circuit, what discovery do you want first? You know, emails, billing records, GAL communications, assignment records, depositions. What do you think is there that you would get if you would want a discovery? What do you want? What's your wish list?
I want tax returns and I want bank accounts, and I'm going to find the money and I'm going to follow it, because we all know, even though the judge may not want to acknowledge it, I know what's going on. This is like La Costa Nostra. You pay tribute up the line. This Judge Hilton, these judges and these lawyers were put in the position they were for a reason. Mm-hmm. And like I said, I have reason to believe in evidence of I won't get into all of it, right? But that's the first thing, but then obviously the cell phone records, my lawyer told me that he texts with the judges. You can't do that. He told me he had the judge's personal cell phone number, and that's apparently commonplace.
In the Zoom conference, I don't remember which lawyer said, but she's just offhanded, I stopped by Judge so-and-so's office and talked about this. Just they speak about ex parte communications with judges. In fact, in this, and Rich and I talked about this, in this Vandenberg case, the guardian ad litem Podlowski offhandedly in the text message says, I'm gonna stop by the judge's office whenever and talk about this. They definitely Michael, are having a lot of ex parte communications.
I can do you one better. I have an email that I posted on social media from that same firm that you have on the screen. The same authors are involved. That is in and of itself ex parte communication. Judge Hilton emails one side's lawyer and says, hey, find me some law that supports this position that helps you. I mean, I have them dead to rights. I mean, I haven't. Send that after.
Send that to us. Send that to us. But Rich,
absolutely.
You got another question?
Yes. Are you asking the Eighth Circuit to send it back to another district court judge?
So, so the answer is yes. So the judge did. We haven't addressed it, but the judge did deny my motion to disqualify, which was not ruled upon by another judge. So, as a threshold issue, the judge should have assigned that issue to another judge at the district court level in St. Louis. You can't judge yourself on whether or not you're biased. That's common sense, right? And the statute says that. And then I pointed out that the judge violated the statute. After I filed that order, he continued to move forward and issue orders against me, which you can't do per congressional statute. But anyway, I laid all this out there, and that's why he's saying is, oh, well, he refers to, I mean, I can give you examples, but so I won't even go down that rabbit hole because that'll go another hour. But in any event, I do believe that, yes, there's two issues the Eighth Circuit will have to deal with, which is the Rule 8, dismissal under Rule 8, whether or not 78 pages is too long for a massive RICO conspiracy that I include evidence of and detailed. If you want patterns, I go through detailed allegations. And then also the issue of it goes back down. It shouldn't go back down to Judge Devine. It should go to another judge to rule on whether Judge Devine should keep it. And that was what I was trying to say is Judge Devine is the last person who could have this case. He was appointed to the bench after I exposed all of this by the same people that put him in that position that I'm saying are involved in a corrupt system. And so, I mean, it's just hit so close to home with him. I point to Senator Josh Hawley as a fact witness, and that is Judge Devine's former client. He calls him a coworker. It's Devine's former client, and he doesn't even acknowledge it. He skirts the issue. I mean, it's just like, I mean, it's so easy to look at this and say, oh, this guy is a conspiracy theorist, this, that, and the other. That's why I lay it out so extensively, which is, listen, I know this is hard to believe. This is very hard to believe, but it's true, and I can prove it. and that's the thing. If you read my complaint, anyone looks and reads it, just read the paragraphs of allegations. I mean, I brought in the adult guardian ad litems being used to sell property. I mean, I've got all the use of garnishments, improper garnishments. I mean, I've got it. I've built this thing out. I've spent over a year investigating this. I mean, I've got it figured out. And now I just need to get hopefully get the green light to move forward in litigation.
All right. Rich, any more?
So I want to turn a little bit now to the policy side, and I think that's a good segue to what you're doing in the 2nd Congressional District. You're running for Congress in the Republican primary. You sent us over the Child Protection Act 2027. It's a bill that you drafted. And in it, I think one of the more interesting parts is you would restore prospective. It's an issue of immunity. You think the judicial immunity reform, I think it's William V. Allen, you think that it's central to family court accountability. Can you talk about that a little bit?
Yeah, so what happened is I think this is 1986, but you cite the case correctly. The United States Supreme Court said, look, we read the Constitution and we looked at the case law, and under the Civil Rights Act, you can sue a judge and recover your attorney's fees. You can't recover damages, but you can recover your attorney's fees. And after the Supreme Court reached that, some years later, Congress amended that act to remove that and make it clear that you cannot recover your attorney's fees. So my approach here is always, what's a practical solution, right? I'm not hitting for we want jury trials, we want all this other stuff. All I'm saying is, what's actual doable? What can we get done in Congress? And that's what we can do. And so that's one piece of it. I hope we get to the other. But I believe that we should go back to the state of the law that the United States Supreme Court held was applicable, then was changed by Congress. Because at a minimum, you should be able to challenge these judges and recover your attorney's fees. It's hard enough to find a lawyer. Wasn't able to find one that will litigate this on your behalf, but they're certainly not going to do it if they're not going to win their fees from the state government, who ultimately would have to pay the fees on behalf of the judges.
You mentioned Title 4D, which is the child support part of Title 4. What do you want to do with that?
So here's the thing. We've got, and you both know this, right? So I don't mean to, so we've got a separation of powers. We've got three branches of government here. So what is the way that the legislative branch, what can Congress do to influence the state and federal courts, which are judicial branches? And then we got the issue of sovereign immunity. So but what they can do, it's easy. So Title 4D is grant money. And that raises all kinds of complications when you look into challenging it. But they can tie the payment of these annual payments that are, hundreds of millions of dollars to the states. They can tie that to the states complying and passing an oversight system, which it's 8 pages long. I don't want to lay it all out there. But basically what I'm saying is the states, we can't force them to do anything from Congress that I think we can practically get done. But what we can do is say, listen, we're going to lose 20-50% of your funding next year if you are not providing oversight and you're not ensuring that the civil rights of litigants are protected in state family court system. And so that's the way, in my opinion, that is the way to tackle this. I've looked at this for a year, and that's the only way to tackle it, I believe, which is why I said, well, I guess the only way to get this done is which is shocking. I never had any idea. And I said, I guess I'm going to run for Congress. If no one else is going to do this, just like this lawsuit, no one's going to do this, I'll do it. And so I'm running for Congress for the 2nd District and as a Republican.
You're definitely part of a growing pattern of people wronged by family court who throw their hat in the ring. And it's on the county level. We interviewed 2 women from Orange County, the state level. We interviewed Bailey Templeton. You're running for Congress, and so was Terry. I forget her last name, but Terry LaPointe running in Alabama. So, and there are many others. That I think is good, because that's how you get the issues out there. And as Rich said, that's often how it goes, that you are exposed, if you will, to the way the law is working that's bad, wrong. And by that exposure, you're like, well, I want to fix it. And then you run. And so there needs to be a lot more of you, but you can only do what
it's a bipartisan issue, right? I'm a Republican running in a Republican district, so I believe a Republican will get the seat. It's held by a Republican currently, but Democrats are being harmed in the family courts just as much as Republicans, and everyone everyone. The large majority of people either personally were involved or know someone who's been drugged through the family court system, and it's cost them $100,000 to get done what they could have done on a handshake the first week. I mean, it's a total scam. And like I said, it's in addition to that, I want to mention the other thing I'm in favor of is term limits. So in addition to some other items that are consistent with the Republican agenda, But my platform, I think Congress needs more of me. I want to go to Congress, get something done, and then return back to being a private citizen. That's what we need in DC. We don't need lifetime politicians. That's where this corruption comes from. I mean, it's inherent and incessant within the system that exists. So, I mean, that's what I think. We need turnover.
Rich, any more questions?
In the bill, it had some really cool stuff. Family court czar. I thought of Michael Volpe immediately. Family court committees, oversight appointees, state compliance offices, public complaint systems, impeachment candidate reports. What parts of that structure do you think matter most? What would be, right away change?
It's the lack of transparency. So, we could go on, talk all day about family court and the lack of transparency, but there should be some way for people to see, or at least a family court czar, someone in the federal court. There needs to be transparency of what's being reported and what's being done about it. And there needs to be an objective commission, or if you will, a federal group that can investigate it. Pick up the phone or go visit somebody and pick a state. I don't know. Or Michael, you're in Illinois. Somebody in Cook County files a complaint against the judge. It turns out it's all true, but nothing happens. That should be made available to this congressional committee that I propose. So that, and then if the state of Illinois is not going to do anything about it, and they're not even going to launch an investigation. I provided that email that we talked about a moment ago that is ex parte communication. I gave that to Judicial Commission. They sent me a letter, said they held a vote and they're going to close it. They're not going to do an investigation on it. So, I mean, when you have those situations, someone has to provide oversight. And we can't, Congress cannot dictate, hey, you have to move this judge, the state court judge off the bench. But what they can do is say, we're pulling $100 million. And as soon as they do that, or the exposure is there, that's what I think motivates the state to actually, address this issue. It's all about money, unfortunately. That's how, and I've learned that. I've been practicing law for 26 years. It's all about money here. And that's what's going on. That's why this is, and in my opinion, that's why I'm not being, this case is not allowed to go forward, is the ripple effect of acknowledging that what I'm saying may be true. It is true.
Here's my problem with your proposal. Family court is a state issue. You want to insert the federal government through a congressional committee into a state issue. And I don't like that. What do you say to me?
I agree. It's an exception to the rule. And I don't generally like that. Like I said, I'm a Republican. I don't think the federal government should meddle in state business. But here we have a proof. My case, I emailed the United States Department of Justice 17 times. Mm-hmm. If they're not going to do anything, and I emailed the state of Missouri, I put every actual notice, gave the evidence to anyone and everyone in the state of Missouri. So if we use that as an example, if the states refuse to act, at a minimum, the federal government has to at least say, we're giving you free money, we're going to give you less. That's all I'm saying. They're not coming in saying that judge can no longer be a judge. What they have the ability to do is say, instead of giving you $100 million, we're going to give you $50 million so you get this cleaned up.
Right. I think that if it's tied to the money, there's something.
Mike, I think that, it's also in our lives, you have to think that there is federal oversight over a heck of a lot that goes into what we.
But is that good? Is that good?
No, I think it is. I'll give you one example: the NTSB. Right? You have one of those big bus crashes, they say on the interstate, and you have the investigator there, a federal investigator, seeing what happened. I think that we should get the same thing in family court. When something crashes out that bad in a family court, I think they should send a federal investigator in. We don't have the wreckage on the highway the same way that we have from a bus or from a plane, or something like that. But I think it's enough of an explosion that it calls for a federal monitor or a federal, watchdog. I don't think it's out of the pale to say that that's necessary here.
I think it's in this instance, it's mandatory. I mean, it's screaming out for it because it's not being addressed. I mean, you've seen it. You guys report on it day in and day out. No one's doing anything about it, and no federal.
You don't know if the federal government would address it either. I'm a lot more with Thomas Jefferson on this. The federal government, they're enumerated, meaning limited set, specific powers, specific things that it does. Everything else is the states. The reason the reason logically that he'd like that, and people who agree with him, is one, then you, as the federal government, you're good at these things and nothing else. And then the states are laboratories for ideas for everything else. So if something doesn't work in one place, then you don't do it there. And once the federal government starts meddling, then they become this massive government. The other thing that Jefferson believed, and people like him, the farther away you are from something, the less you understand. The state understands the local school district a lot less than the county and a lot less than that local. And so if you get this federal committee that's looking in Idaho and Illinois and Florida, and they're in DC, they understand less than what would be in the state. We'll see. That philosophically, I don't necessarily like that idea, but
So Michael, I think I know where you're going with that. I think you were touching on the Department of Education example. So on that, we agree, right? But I'm not talking about forceful intervention. What I'm talking about is strings to money. If we're going to give you, if Jefferson didn't address this, if we're going to give you $100 million to specifically fund a program that is violating United States citizens' rights, we're going to tie that to, you have to have some oversight, or that's fine. Just you don't get the money. You don't have to do anything. It's not compelled. It's if you want the money, change the system.
I definitely don't want to put words in Thomas Jefferson's mouth, but he would just be against all of the federal programs to begin with and just make them zero. And then you'd have federal oversight of nothing because there wouldn't be a program. As I said to Rich last time, what you can do in Congress is eliminate Social Security Title IV, the entire, just eliminate it. CAPTA, ASPA, the Violence Against Women Act, and fatherhood.gov. Violence Against Women Act is pro-woman, fatherhood.gov, pro-man. These are all federal programs that push money into state family courts and into CPS. And the more money there is, the more it corrupts it. If you starve the system of money, a lot of that corruption goes away. Not all, but a lot.
So on that just big picture proposition, Michael, I absolutely agree with you. I can't believe in today's climate, and we'll go back to my federal judge, to think that there's not corruption out there. Right. I mean, it's a bit naive at best.
Right.
I mean, we know corruption is everywhere. And the fact, so I found it here, similar to what was found in the Cash for Kids scandal in Pennsylvania, where federal judges went to jail for state court judges went to jail for 27 years for in the juvenile system. I mean, this is not a never heard of before situation. I found it in St. Louis County. And yeah, to think, oh my gosh, is corruption taking place with Title IV that is related to Title 4D money that pumps in hundreds of millions of dollars? It wouldn't be as a general proposition, no one would disagree with that is at least possible and plausible. Right. More importantly, tie that back to Judge Devine's ruling. It's plausible.
Right. John Allen Muhammad, the Beltway sniper, got money through fatherhood.gov to go after his ex-wife, Mildred, who they just did a documentary about. Unfortunately, the judge ruled against him. And a lot of people think it was he lost custody one final time, and that's what set him off. And then he became the Beltway sniper. But it was that federal program gave him money to go get a lawyer to try to get custody. You get rid of these programs, you get rid of a lot of the money. Rich, you got any other questions? Go ahead.
Yes. Two-parter. Beyond family court, what are your three top issues for Congress, and why should Republican primary voters choose you over the rest of the field?
Okay, so so Michael, you're going to love this, but again, I'm a lifelong Republican. On this issue, it doesn't matter what your party is, but we need a smaller government. I mean, it's just out. This Title IV is an example, Michael, which is there's so much money coming through and out of the federal government. It just has to end, right? So one, I propose a hiring freeze, and I propose early retirement packages throughout the federal government. So between those two, we can just, I mean, it's like anything else. If you give someone a budget, they're always going to spend it or more so they can get it again next year. Right. So we've all seen this in our personal lives. But if you freeze or you decrease the budget and you just hold it that way, and trust me, the federal government will operate just fine with fewer employees and spending less money. And then on the same, so related to that is If the federal government can spend less money as it should, it's a behemoth. I don't know if you ever been to DC and walk around. I mean, it's shocking. Everything is paid for by tax dollars, that entire city, every building. But then you can lower the tax rates. We don't need to get into what tax bracket it is but just as holistically, people are paying way too much in taxes. I don't think anyone would disagree with that. So it is because all of these programs just suck money out from the taxpayer, and it gets redistributed down through these pet projects or otherwise. You know, I don't want to get into the examples, but you can see where the corruption is within the around the country. That is being more and more revealed every day.
Half of the government agencies I'd like to eliminate and sunset. And then you'd have as one what it sounds like is, as one President Twilight a lot, the era of big government is over. That's what you would implement. Rich, I think you had a second question.
Yeah, why should the Republican primary voters vote for you as opposed to the rest of the field?
Well, because I'm not a politician. That's the first one. And I don't want to be a politician any longer than to get this act or a final version of this act implemented, right? I have no aspirations to become a lifelong politician. I never intended to run for Congress. And I'm running against an incumbent who has been there for, I think, 23 years. I don't want to get it wrong. And if you look at the midterms, I guess this doesn't answer your question, Richard, but I think it does actually, now that I'll tie it in. If you look at the turnout in the voting at the last midterms in this same district, it's been changed under the new map. But she's beatable because people want a new face in that seat. So somebody I think can beat her. I hope that it's me. But we need fresh blood. We need to rotate in people, and then we need to rotate them back out. And that's what I send me there for a short term. Let me do what I can do, and then let me go back to living a private life. That's what we need in DC.
Most people who are going to be voting in the primary don't care about family court. So how do you get them to vote for you if your main platform is to get this bill passed?
So again, I think if you actually talk to people, I think they are connected. They all know a story within their family. It might be a cousin or cousin's, husband or wife, but people are connected to this, right? But again, if you tie that to term limits and a smaller government, I mean, the Republicans should be interested, but just we just got to get new 90-year-old senators. It has to be a thing in the past. And we can pass this, by the way, by grandfathering term limits in. No one's going to vote to lose their own job, but they'll vote for term limits.
Well, they'll lose their job at some point, but with the term limits. But yeah.
If you grandfather it in, and there's a way to strike that deal, everything is negotiable. In DC, that's what I've learned.
The government was a lot smaller in the 1990s, and the economy was a lot better. And Republicans, ironically, tell you that's just a coincidence because they don't want to give Bill Clinton any credit. But I don't think it's a coincidence. You reduce the size of government, that reduces the amount of money the government spends, which frees up business investment because the government borrowing crowds out business investment, and business investment is a lot more efficient. You want the Elon Musks of the world to borrow money, put capital in, and start businesses, not the government with all of their stupid programs. That's not as efficient. That's what Bill Clinton said in 1993, and we've never had a decade like the 90s economic-wise. Every measure was just awesome. So that's
smaller government does not equate to fewer benefits. You can improve.
Go ahead.
And when I say benefits, it doesn't mean you're going backwards socially or politically. That somehow, okay, I'm gonna lose something in my life somehow. I'm not going to get the advantages provided by the federal government if you cut the budget. It's that all of that can be provided. Well, some of it should be gone. I agree with you there. You got to trim the federal government, but it's too big of a behemoth. And you can be a Democrat and agree with that, and you can be a Democrat who knows someone who's been harmed by the family court systems, particularly in St. Louis, and that's why in Missouri, I point this out, the August 4th is the primary vote. It's an open primary, so Democrats that I'm hoping to pull from the Democratic side, at least for the primary, to make me the Republican candidate. So Democrats can vote for me in August and still vote for a Democrat in October. But, to the extent it's likely Republicans are going to get this seat anyway. But at least as far as to have a challenger who believes like you, that the family court system has to be rearranged and that we have to shrink government, we have to lower taxes, and we need term limits, all these things, that goes across party lines. And so, like I said, it's a huge uphill battle. I'm not sitting here saying I'm guaranteeing a victory. But just like the federal court case, I'm doing everything I can think of. Everything I can think of, I'm doing to end this, because somebody's got to pull this off. And I think I'm the one who can do it. It's going to take years. The federal litigation, it's going to take a couple of years, one way or the other, to play out. I'm patient. I hope everyone else is patient. These little setbacks, one battle does not lose the war. So we're going to get this done. Just stick with me. I know what I'm doing. I have the proper legal theories, and I'm going to have to go up to the Court of Appeals, and I'm going to take hits. I'm going to get sanctioned. But like I said, I'm happy to do it because somebody has to. These children are being used as pawns, and they're being used to drag cases out, and they're suffering. I witnessed it with my 2 children. I mean, it's outrageous, and I'm going to do everything within my power to end it.
Rich,
where do you stand on free speech and big tech censorship?
Big free speech and big tech. Oh, I see where you're going. Okay, I'm sorry. I just want to interpret. So I believe in the broadest definition of free speech. Right? I think that it's public forums have to be public forums. And I think I know what you're getting to is the use of algorithms and all these other things to limit speech and under the guise of something else, right? Is whether I don't even know which ones they would want to use, but I generally think that we need an open marketplace of ideas on every forum, whether it's in person, by phone, but social media wise, I think what you're getting at is, we can't have what we're finding has happened is the federal government influencing technology providers to influence the speech that people see. And that's what's been happening, we know. And that should be prohibited and, going forward for sure.
Doesn't YouTube and Facebook have free speech? So you may not like their algorithm, but it's there. You didn't build Facebook. Mark Zuckerberg and others along with him, they built it. So he gets to run it. So if he wants for liberal voices to flourish and conservative voices not to, tough noogies. No one's forced to use Facebook. No one's forced to use YouTube. Don't they have free speech? It's theirs. It's
if Mark Zuckerberg wants to go and sit in front of Congress and be honest and say, and I'm not going to, let's just say whether it's Republican or Democrat, pick one. If he wants to sit there and say, my algorithms favor this party, then go for it. Just be upfront and honest about it. The problems is what's going on behind the scenes, right? And so I agree with you and disagree with you is that if it's not free speech if you secretly manage and cultivate the speech that gets out there. So I agree with you that from capitalism standpoint, if I want to open a Democratic only version of Truth Social, then I should be able to do that.
Right? It's already open.
They call it Blueski, or at least Senator Kennedy does.
Right. Okay. But and I think there is influence. I worry that the influence goes the other way. No one, first of all, there's not a lot, but there are enough big social media companies that it's not like you have to only use one. And the government then forcing it the other way isn't any better.
As long as it's transparent. That's right. I believe as long as we know what they're doing.
They're not required to be transparent. They're not. YouTube and Facebook isn't required to show you their work for why this thing as opposed to this other thing winds up at the top of your feed. They're not required to do that, and it's theirs. Ultimately, the most important thing is their free speech, because what some people argue is that they are so big that Facebook and YouTube and Twitter and a few others that it's like a public square. So they've gotten so big that it's all of ours. And so as a result, they have to do certain things. And I totally disagree with that. They don't have to do anything. You didn't build it, they built it. The information superhighway happened because of their work, and they can do what they want. That's their free speech.
So I just
Mike,
froze for the last
I
20
thought
seconds.
it was
Let Matt,
Mike,
let Matt hold that thought. Let Matt go, and then you finish the thought. Go ahead. Matt, go ahead.
No, I was just going to say I lost my connection. I don't know if you noticed. I was waving my hands for the last 20 seconds. I didn't hear any of that.
All right, then Rich, go ahead, and then I'll re-say it. Go ahead, Rich.
Well, Mike said he thinks the big tech companies are responsible for information superhighway. I thought it was Al Gore who invented the internet, but those are just details. But my question is, do you think Section 230 has to be tweaked?
Elaborate what Section 230 is in which context.
That's the immunity. That's the immunity that for the big tech companies for the platforms. It's platform immunity. They're hosts, and so they cannot be held liable vicariously for the content. There's very, very strong Section 230 immunity.
So I think you're going. I see where you're going. So I think as long as there is transparency, then I think they should have immunity for providing an open marketplace of ideas. Now, if they shift it, then they should not have immunity if they're manipulating the process. So that's kind of where I come down on that generally. And yeah, I'll be honest, at Section 230, I wasn't sure which particular law you were referencing.
That's an explainer. What I said is some people argue that YouTube and Twitter and Facebook and a few other social media companies, they're so big that they represent the public square, meaning it's like the public square. And so as a result, they should be regulated more because everyone goes there, and it should be fair in whatever way. And that's what I disagree with. That it's not. It is the information superhighway. It's the public square in some sense because everyone's going there. But I don't think that the government should meddle in what YouTube and Twitter and Facebook are doing, because it's still that was created by certain people, and it's theirs. It's not ours. It's theirs. Most of them are publicly traded companies. So if you want to own a part of it, just go buy their shares. But that's what I worry that we're going to go the other way, that in an effort to create free speech on these places, we're going to create all kinds of regulations that govern the way that these places operate in a way that violates their free speech.
So I agree with I agree with you on the big picture, which is I view it from the legal context is there antitrust monopoly of
that's
the public fair.
Yeah. Right.
Yeah, which is, do we have an issue? And I agree with you, Michael, at least now, I mean, maybe in this point in time, we have enough competitors out there that are separately owned that, like I said, Truth Social, it should be allowed to be, a conservative voice, or the other one that Richard mentioned for the Democrat or whatever in Facebook and TikTok. There is enough diversity and platforms that I agree with you that you can get your message out anywhere you want, and you shouldn't be no particular platform should be forced on, as long as it's transparent, as long as we all know what's going on. That's the issue. We lack transparency.
Right. The only one of the tech companies that I think is a monopoly is Google or Alphabet, by owning Google, Chrome, YouTube, Gmail. If you guys don't think it's a monopoly, try to go one day without using a Google product and see what happens. If you use Gmail, you're not using email. You'll have to go to like Bing or Yahoo.com for your searches. If you use a Google computer, you're going to have to use another computer. No YouTube that day. It's almost impossible. That's the only one that I think is a monopoly. But I don't think that Facebook, YouTube, because YouTube is owned by Google. Twitter is not a monopoly. I don't know, the social media companies, except for YouTube, which is owned by Alphabet, are not monopolies. But and Google got they get off the hook, but that's separate. I do uh, believe in the antitrust laws, and I definitely think that if a company that gets too big must be broken up, because if you're anti-competition, that's not capitalism. You are using your size to drive others out of the market, to bully people, and that, that you can't have that in capitalism. But the only company who I think is like that is Google or Alphabet, the holding company.
The one thing I will say for the DOJ that I agree with, they're keeping an eye on that issue in the technology space. And I agree with you, Michael, is that you can implement antitrust principles and pick that up in any area and implement it. And that's why I specifically said in today's, maybe Facebook had a monopoly 10 years ago, but today I agree with you. There are enough different towns, public squares that you can get your voice out.
Right. Yeah. Rich, anything else you wanted to add?
No, I think we covered a lot of ground today.
All right. Any last words?
Matt Grant for Congress.org is my my website there. I'm accepting political donations, obviously specifically for the campaign.
And there's the website.
You can follow. Yep, that's my my website there. And if you're in Missouri, hopefully you've already heard of me, but we'll be organizing some events within my district, the 2nd district, to get the word out. Like I said, if I lose, and which would be Vegas odds are against me, right? I'm no fool. But if I can get, all of this is about, can I create progress for our ideas, which is gain more exposure, more traction, so people know that there's corruption in the family court. That's my goal. I mean, if I'm not the one to be able to stop it, I'm going to do what I can, and for the next person to come along and to do it. So, Matt, I mean, people need to know what's going on in the government.
Matt, what's primary day? What day is primary day?
Tuesday, August the 4th.
Right.
And both Republicans and Democrats can ask for a Republican ticket and pick me if you're in the first.
That's what an open primary means. And Bailey Templeton lost, but she did a lot of events, and she talked about her story, and she talked about CPS and the corruption and the abuses. And a lot of the people she spoke to probably had no idea that it was happening. So I think it definitely moved the ball forward. All right, Matt, thank you for being here.
All right. I appreciate it, gentlemen.